The air in Washington that winter carried a peculiar charge, a static crackle of anticipation and division. It was the residue of a political war fought not with armies on distant shores, but with filibusters in the Senate, with vitriolic cable, news segments, and with the furious, desperate energy of a nation wrestling with its own identity. The Patient Protection and Affordable Care Act, a legislative behemoth born of partisan fury, was no longer just a law. It had become a symbol, a line drawn in the unforgiving sands of American ideology. For some, it was a promise of security, a moral imperative. For others, it was an existential threat, a tyrannical overreach of federal power that gnawed at the very roots of individual liberty. The battle had raged through the halls of Congress, spilled into town halls across the heartland, and now it had arrived at its final, inevitable destination. The cold, unforgiving marble of the Supreme Court of the United States, the law's fate, and with it, the trajectory of a presidency and the definition of constitutional limits, rested in the hands of 9 robed figures. In Florida, far from the capital's manufactured snowfalls and political chill, the sun beat down with its customary indifference. But for the state's Attorney General, Pam Bondi, the heat was internal. She was a central architect of the coming legal storm. Elected on a wave of Tea Party fervor, she had inherited and then fiercely championed the multi-state lawsuit that now stood at the precipice of history. This was not merely a case on a docket. It was the fulfillment of a promise, a crusade. Her political identity was inextricably linked to the dismantling of this law. The legal challenge was a complex tapestry woven from threads of constitutional law, its abstract theories of federalism, and the raw, tangible anxieties of millions. The core of the argument was elegant in its simplicity. Could the federal government, under the guise of regulating interstate commerce, compel an individual to purchase a product? Could it force a citizen to enter a market simply by virtue of being alive? To Bondi and her coalition of 25 other states, the answer was a resounding, unequivocal no. To them, the individual mandate was not a regulation of commerce, but a creation of it, an unprecedented assertion of power that, if upheld, would render the Commerce Clause a boundless grant of authority, effectively erasing the line between federal and state power, between a government of limited powers and a government of absolute control. The legal teams had spent months, years honing their arguments, preparing for this moment. On one side stood Paul Clement, a titan of the Supreme Court bar, a man whose eloquence and intellectual agility were legendary, had served as solicitor general under George W. Bush and was now the chosen champion for the states. His mind was a fortress of precedent and constitutional theory, his delivery a masterclass in calm, persuasive reason. Against him stood Donald Verrilli, the solicitor general for the Obama administration. He carried the weight of the president's signature legislative achievement on his shoulders. The pressure on him was immense, almost suffocating. He had to defend a law that was deeply unpopular with half the country and legally suspect even to some of its supporters. His task was to convince a skeptical court, particularly its mercurial swing vote, Justice Anthony Kennedy, and its new, institutionally minded Chief Justice, John Roberts, that this novel exercise of federal power was, in fact, well within the bounds of a century of established jurisprudence. The stage was set. The briefs, thousands of pages of dense legal argument, had been filed. The amicus briefs, a chorus of voices from every corner of society, had been submitted. The nation waited. The court, in a rare move that underscored the case's historic nature, had scheduled an extraordinary 6 hours of oral argument over 3 consecutive days. Each day would focus on a different critical question. Day 1, the arcane, but potentially case-ending issue of the Anti-Injunction Act, which could prevent the court from even hearing the case until the law's penalties were first paid. Day 2, the main event, the constitutionality of the individual. Mandate itself. Day 3. The questions of severability. If the mandate falls, does the rest of the law fall with it? And the massive expansion of Medicaid. The air inside the courtroom on the first day was thick with a silence that felt heavier than sound. The room itself is an exercise in power and permanence. The soaring ceiling, the heavy velvet curtains, the dark, polished wood, all designed to humble those who enter. The press gallery was packed, reporters hunched over notebooks, their pens poised. In the public gallery, a lottery of lucky, anxious citizens sat shoulder to shoulder. Pam Bondi was not at the lectern. That was Clement's role. Her presence was felt. She was the political engine, the public face of the challenge. Her victory in the 11th Circuit Court of Appeals had been the most sweeping repudiation of the law, a judgment that had declared the entire act void. She sat among the spectators, her expression a mask of focused intensity. Her calm, almost serene public demeanor belied a fierce, competitive resolve. She was watching the culmination of her work, her entire political strategy now in the hands of another man before 9 arbiters who held the power to validate or shatter her efforts. The first day's arguments on the Anti-Injunction Act were technical, a dense thicket of statutory interpretation. The justices' questions were sharp. Probing, it was clear they were eager to get to the main constitutional questions, to the heart of the matter. The consensus among the court watchers was that the justices would find a way around this procedural hurdle. They had not granted this much time, stirred this much national anticipation to dismiss the case on a technicality. The real battle would begin on day 2, when Paul Clement rose to speak on the second day. A hush fell over the chamber. He was a familiar figure at this lectern, comfortable in the crucible. His argument was a direct, powerful assault on the individual mandate. He spoke of a foundational constitutional principle. The government can regulate activity, but it cannot compel it. Buying insurance, he argued, is an economic decision. The choice not to buy it is, by definition, economic inactivity. He drew a stark line. The government can force you to buy health insurance. What can it not force you to buy? Can it mandate the purchase of broccoli to improve national health? Electric cars to combat climate change? The broccoli, horrible as it came to be known, was a potent, easily grasped metaphor for a slippery slope of unchecked federal power. The liberal justices pushed back hard. Justice Ginsburg, her voice small, but her intellect immense, pointed to other federal mandates, like the requirement for men to serve in a militia. Justice Breyer, ever the pragmatist, spoke of the unique nature of the healthcare market. A market no one can truly opt out of, as everyone will eventually require medical care. The debate was a high-level intellectual sparring match, the justices and Clement weaving through decades of precedent. From the new D'Alera case of Wickard v. Filburn, which had vastly expanded federal power, to the more recent cases of Lopez and Morrison, which had begun to impose limits. Then it was Donald Verrilli's turn. The tension in the room ratcheted up. As he began to speak, his voice faltered. He took a sip of water, his hand visibly trembling. A cough, a cleared throat. The moment, broadcast live via audio to a waiting world, was excruciating. The immense pressure seemed to be manifesting physically. He was defending a law that was anathema to the court's conservative wing, and his initial delivery was shaky, unconfident. The conservative justices were relentless. Justice Scalia, with his characteristic intellectual pugilism, pressed Verrilli on the limits of his theory. If this is constitutional, what isn't? The broccoli question returned, and Verrilli's attempts to distinguish the health insurance market seemed, too many listeners, to be failing. Justice Kennedy, the man all eyes were on, sounded deeply troubled. He spoke of the government creating a relationship of compulsion between itself and the citizen, a fundamental shift in the nature of American governance. Chief Justice Roberts, largely silent through the initial salvos, began to ask his own questions. His style was different from Scalia's overt combativeness. It was more surgical, more analytical. He, too, seemed focused on the question of limits. He posed a hypothetical. If the government can force people to buy insurance to lower costs for everyone, could it also force people to buy a new cell phone to help stimulate the telecommunications market? His questions seemed to align with the core of Clement's argument, reinforcing the idea that the government's theory lacked a clear stopping point. To the observers in the room and the millions listening across the country, the tide was turning into a tsunami. The consensus was forming. The mandate was going down. The questioning from Kennedy and Roberts, the two crucial votes, was not just skeptical. It sounded hostile. Verrelli seemed unable to find a foothold, unable to present a limiting principle that could satisfy the court's powerful center-right. For Pam Bondi and the coalition of states, it was a moment of profound, almost unbelievable vindication. The arguments they had been making for 2 years, arguments often dismissed by opponents as radical or frivolous, were now being echoed from the nation's highest bench. The intellectual foundation of the president's law was crumbling under the weight of Socratic scrutiny. Mood among conservatives was jubilant. Liberal commentators were in a state of despair, already writing pre-obituaries for the Affordable Care Act. The narrative was set. The Chief Justice, a reliable conservative vote, and Justice Kennedy, the guardian of federalism, were poised to lead a 5-4 majority in a landmark decision striking down the individual mandate. The third day of arguments arrived, carrying with it a sense of denouement. The focus shifted to survivability and Medicaid. But the shadow of the previous day's hearing loomed over the proceedings. The central question now was not if the mandate would fall, but what else would fall with it. Paul Clement, returning to the lectern, argued that the mandate was the heart of the law, the engine that made the whole complex machine run. Without it, provisions requiring insurance companies to cover people with pre-existing conditions would create a death spiral. Healthy people would wait until they got sick to buy insurance, bankrupting the system. Therefore, he argued, the entire law must be struck down. It was here, in this seemingly secondary argument, that the first subtle tremor of a coming earthquake was felt. Chief Justice Roberts began to question Clement with a new, unexpected line of inquiry. His focus shifted from the abstract principles of federalism to the practicalities of the judicial role. He seemed deeply uncomfortable with the idea of the court, an unelected body, striking down an entire massive piece of legislation enacted by the elected branches of government. He pressed Clement on the sheer scale of the law, its hundreds of provisions, many of which had nothing to do with the individual mandate. Is it the court's job, he asked, to perform this kind of radical surgery, to sift through a 2,700-page law and decide which parts can survive without its central provision? His questions carried a different tone now. They were less about the limits of congressional power and more about the limits of judicial power. He invoked the concept of judicial restraint, the idea that judges should defer to the will of the legislature whenever possible. This was a core conservative principle. Yet he was now aiming it directly at the conservative champion Paul Clement. A new tension filled the room. This was not the same Roberts from the day before. The certitude that had filled the air, the sense of a clear 5-4 conservative victory, began to dissipate, replaced by a fog of confusion. What was the Chief Justice doing? Was he playing devil's advocate, testing the arguments for his own internal deliberations? Or was he signaling something else entirely, a different path forward that no one had anticipated? The Solicitor General Verrelli had a chance to recover during the severability argument. He argued that the court should save as much of the law as it could, that Congress would have wanted the other provisions to stand, even if the mandate fell. But the most significant drama was no longer happening at the lectern. It was happening on the bench, inside the mind of one man. The focus of the entire legal and political world narrowed to Chief Justice John Roberts. He was a product of the conservative legal movement, an appointee of a Republican president, a man whose judicial philosophy was thought to be clear and consistent. He had famously compared the role of a judge to that of an umpire, simply calling balls and strikes. But now, he seemed to be wrestling with something far more complex than the strike zone. He was wrestling with the legitimacy of the court itself. The institution he now led had become increasingly perceived as a political body, its decisions mapping almost perfectly onto the partisan divides of the country. A 5-4 decision along ideological lines to strike down the signature achievement of a sitting president would be seen by half the country, not as a matter of law, but as a partisan act of immense consequence. It would pour gasoline on the fire of political polarization and could do lasting damage to the public's perception of the court as an impartial arbiter. As the arguments concluded, an unsettling uncertainty descended. Of a conservative triumph was replaced by 1,000 frantic questions. Pundits and legal scholars parsed every word, every question from Roberts, searching for clues, for a hint of his true intentions. Had he been with the conservatives all along, just testing the arguments? Or had the prospect of leading the court in such a politically explosive act caused him to seek an off-ramp, a third way that could avoid a constitutional crisis? For Pam Bondi and her allies, the confident sense of victory gave way to a gnawing anxiety. They had won the argument on the Commerce Clause. The intellectual core of their challenge had been validated by the court's most powerful voices. But a legal victory on one point did not guarantee a political victory in the end. The fate of the law, they now realized, might not be decided on the clear, logical grounds of the Commerce Clause, but in the murky, pragmatic calculus of institutional preservation. The months between the arguments and the decision in late June were a crucible of speculation. Rumors swirled. Anonymous sources claimed to know the outcome, often with conflicting accounts. The nation held its breath. The case had transcended law and politics. It had become a national obsession, a referendum on the very nature of American government. Finally, the day arrived. The courtroom was once again packed, the atmosphere electric with an almost unbearable tension. The justices took the bench. The preliminary business of the court was conducted, each minor case announcement ratcheting up the suspense. Then, the Chief Justice began to speak. He announced that he would be reading the opinion. For the court in NFIBV, Sibelius, in the tradition of the court, this meant he was in the majority. A wave of relief washed over the conservatives in the room. The chief was with them. The law was going down. Roberts began by addressing the Commerce Clause. He methodically, systematically dismantled the government's argument. He adopted the reasoning of the challengers, the logic championed by Paul Clement. The power to regulate commerce, he wrote, presupposes the existence of commerce to be regulated. The federal government cannot use this power to compel individuals to engage in commerce. The individual mandate was not a valid exercise of the Commerce Clause. It was unconstitutional. He affirmed the central premise of the state's challenge. A stunning victory.
Oh.
In that moment, it seemed as if Pam Bondi's crusade had succeeded, beyond her wildest dreams. The Chief Justice of the United States had just enshrined her side's view of the Constitution into law, drawing a clear, bright line against federal overreach. But Roberts kept speaking. Having closed the front door on the Commerce Clause, he then walked around to the back and propped open another. He turned to the government's alternative argument, one that had been treated almost as an afterthought. During the oral arguments, the taxing power, the law, he noted, did not call the penalty for not having insurance a penalty. In the text of the statute, it was labeled a shared responsibility payment. This payment was to be collected by the IRS based on income and paid with annual tax returns. While Congress had called it a penalty, it functioned like a tax. And the power of Congress to levy taxes is broad, far broader than its power to regulate commerce. The question, Roberts reasoned, was not whether the individual mandate was the wisest policy. The question was whether it could be justified under any plausible reading of Congress's constitutional powers. While it was not a valid exercise of the Commerce Clause, it could be read as a tax on the choice to go without insurance. And under the court's precedents, that was a permissible exercise of the taxing power. He was saving the law. A collective gasp, both literal and metaphorical, went through the courtroom and across the nation. He had given the conservatives the constitutional principle they had fought for, then used a different constitutional principle to deny them the victory they craved. He had threaded a needle that no one had seen. He struck down the core legal argument against the law, then upheld the law itself. The opinion was a stunning act of judicial jujitsu. He had built a 5-4 majority to declare the mandate unconstitutional. Under the Commerce Clause, joined by Justices Scalia, Kennedy, Thomas, and Alito. Then, he had joined the four liberal Justices Ginsburg, Breyer, Sotomayor, and Kagan to form a different 5-4 majority to uphold the mandate as a tax. He was the only justice in both majorities, the solitary pivot upon which the entire decision turned. The twist was devastating for the law's opponents. They had won the intellectual war, only to lose the actual one. Pam Bondi's name and reputation had indeed skyrocketed. She was hailed as a hero by the conservative movement for leading the fight and for forcing the Chief Justice of the United States to concede their fundamental point about the limits of federal power. The debate did go viral, solidifying the legal and political battle lines for a generation. But the law, the object of their 2-year crusade, remained standing. The victory felt hollow, a constitutional trophy and a lost cause. The fallout was immediate and intense. Conservatives who had once lauded Roberts as a brilliant legal mind now branded him a traitor. They accused him of rewriting the law from the bench, of contorting the statute to save it from its own unconstitutionality, of sacrificing legal principle for political expediency. The man who had promised to be a humble umpire was now accused of having rigged the game to achieve a preferred outcome, not for a political party, but for the perceived stability of his own institution. The fall from grace within his own ideological camp was swift and brutal. The unresolved ethical dilemma lingered long after the headlines faded. John Roberts performed an act of profound judicial statesmanship, navigating a treacherous political landscape to protect the court from the appearance of partisanship and prevent a constitutional showdown. Or had he betrayed his judicial oath, abandoning principle to engage in the very kind of political calculation that judges are meant to stand above? The question echoed in the marble halls of the court and in the divided nation beyond. I had exposed a weakness, not in his own reasoning, but in the very fabric of a system where law and politics are so deeply, perhaps irrevocably, intertwined. The pause that had defined the oral arguments the moment of quiet. Contemplation on the bench was now understood not as a sign of weakness, but as the silent, solitary birth of a decision that would satisfy no one completely, infuriate millions, and forever change the legacy of the man who made it. Pam Bondi and her allies had forced a reckoning. But the final judgment was one none of them could have ever predicted. A resolution that left the nation's deepest divisions not healed, but etched permanently into the law of the land. The weakness that had been exposed was not in a single man's logic, but in the fragile hope that the law could ever truly be separated from the raw, relentless pressure of politics. The fight was over, but the war was not. The decision was not an end, but the beginning of a new, more bitter chapter in the endless struggle over the meaning of American liberty. The quiet, calm delivery of the Chief Justice on that June morning had done more than save a law. It had created a new set of battle lines, ensuring that the conflict, in all its fury and complexity, would rage on. The suspense of the courtroom had given way to the certainty of a continuing, unending national debate. A debate that the Chief Justice's calculated pivot had not resolved, but merely postponed for another day, another court, and another generation. The story of the Affordable Care Act's survival was not one of clear victory or defeat, but a deeply American tale of ambiguity, compromise, and the enduring, unresolvable tension between principle and power. The defining moment was not a piercing question from a lawyer, but a silent, momentous choice by a judge. A choice that left an indelible mark on the Constitution and the country it governs.